Hi, I'm Josh Zugish. I'm an attorney in the Office of the General Counsel here at CSU, and I'm sorry that I wasn't able to be here in person today in order to meet all of you and talk about the appeal process and the important role that it plays for students here on campus and for the university as a whole. There's just a few quick things that I wanted to touch bases with you on, even though I'm not able to be there, that I like to touch bases and talk about in relation to the appeal process and the important role that you play. Number one is my thank you. It really is a time commitment and an important function and role that you serve, and it is very much appreciated. The second thing that I like to touch on with the appeal process is thinking back. As a lawyer, I love the Constitution. And to think back about some of the actual foundational roots of the work that you're doing in this appeal process at CSU is actually tied to the United States Constitution. For me, I'm a bit of a dork, but I think that that's fun. You may all hear about concepts of due process. That gets tossed out a fair amount when we think about disciplinary hearings, employment matters, all kinds of things. And the idea that people are entitled to due process before something gets taken away from them. And the constitutional foundation of that comes into play with the Fifth Amendment and applies to the states through the 14th Amendment to the United States Constitution. And very generally what it says is that nobody shall be deprived of life, liberty, or property without due process of law. And the courts have recognized over time that there is some level of property interest for students in the pursuit of their education, the attainment of their degree. And the idea is that we can't take away a student's ability to pursue that education, pursue that degree, pursue whatever livelihood or career that they hope to pursue after they're done at CSU, without some form of due process. And generally what due process requires is some form of notice and a meaningful opportunity for a student to be heard before that ability to pursue their education is somehow taken away or negatively impacted through a disciplinary process. So with the process that we have here, we meet our due process requirements by virtue of saying, hey, a report comes in that alleges that a student may have violated the student conduct code. Notice is sent to that student that says, hey, here's what we think the potential violations of the conduct code are, and we want you to come in for a hearing and talk about it. And the student has the option, of course, of accepting responsibility and going through whatever sort of educational or disciplinary sanctions that may flow from that. Or if they think that they haven't violated the conduct code, they have a meaningful opportunity to be heard. They can come in for a hearing, meet with the hearing officer, depending on the facts and circumstances of the case. Maybe there's witnesses involved. Maybe that student brings an advocate or support person of some sort. And they have an opportunity to talk about what happened and why they don't think they should be found responsible for violating the code. And that right there helps cover our due process basis. They've been put on notice of the allegations. They've had a meaningful opportunity to come in for a hearing and be heard and sort of defend themselves. Then from there, the next layer on that due process piece is the appeal process. And the opportunity for a student to take whatever the outcome is from the original hearing officer and have that be reviewed by the appeal committee is kind of the cherry on top of the ice cream when it comes to due process. And so it's very important that we give students that opportunity to say, hey, I disagree with what the hearing officer did. I don't think the process was appropriately followed. I don't think there was enough facts or information to support a finding of responsibility for violating the code. That they have an opportunity to come to you and have that appeal get considered. And so when we think about the appeal process and the importance of due process, I like to share the fact that it has these constitutional roots. It's interesting to me sometimes, the idea that we take something as grand as the United States Constitution. It's old, it's grand, it's a foundational document for our nation. And all of the different laws and such in our society that have flowed out of that Constitution and how we generally govern ourselves, to think that a piece of that, and an important piece of that, flows through onto a college campus and through this disciplinary process, and the role that you're playing, I think is important to keep in mind and consider. The last thing I want to talk about is your role on the appeal committee. So, as I was talking about before, students have notice, they have an opportunity for their original hearing, and clearly if they're appealing to you, they're feeling that something about the original hearing didn't go the way that they believe that it should have. They may think that somehow process was not followed and they weren't given a fair hearing. They may think that the facts or the evidence didn't support the finding of responsibility for violating the conduct code. Whatever their angle is in thinking that this system didn't work right and I want it to be reviewed on appeal, it's important for you to know and understand kind of what the scope of your review is. So there's a couple of things I'd like to go through. And one, I've got my quick cheat sheet notes here about the bases for appeal. Now, when a student wants to appeal, they've got 7 business days to submit that appeal in writing to the chair of your appeal board, to Paul Millett, and set forth their reasons for the appeal. Now, generally speaking, the basis for appeal starts with the idea of whether the hearing was conducted fairly. Does the student allege that the hearing was not conducted fairly and that they weren't given the opportunity to present relevant information? So for you, what you would have to look back at is, all right, I've got a student who says the hearing wasn't conducted fairly, I wasn't given a meaningful opportunity to present relevant evidence to help support my case. And so you look back and say, okay, what's our process? Were they given adequate notice? And then what process flowed with the hearing officer? Did the student have an opportunity to share their side of the story? Did they have an opportunity to present witnesses if they asked to present witnesses? Did they have an opportunity to ask questions of other people involved in the incident if those people were available? Did the hearing officer ask questions that got to the heart of whatever the incident was in such a way that there was an exchange of information where the hearing officer could justifiably make the decision that they did, and that student had a meaningful opportunity to be heard and present their case? So you look at the process piece and get a sense of whether or not you feel as though process was followed and the hearing was conducted fairly. The other piece, and this is an important one, is whether the decision was based on substantial and sufficient information. That is, whether there was information presented in the case that, if believed by the hearing officer, was sufficient to establish that a violation of the student conduct code occurred. So the important piece on that one is the idea of, with the information that was given and what was believed by the hearing officer based on that information, was that sufficient to establish a violation of the conduct code? So it's not a matter of you taking an absolute fresh look at the case and substituting your judgment for that of the hearing officer. Part of what you have to try and do is look through the original hearing officer's lens and say, what is the information that hearing officer heard and reviewed in order to make their decision? And when they made that decision, if we look at it through the lens they were looking at, was there sufficient information to establish by a preponderance of the evidence, more likely than not, that a violation of the conduct code occurred? And if the answer is yes, even if maybe you would have decided the case differently, it doesn't necessarily mean that the case needs to be reversed or that you need to recommend a reversal of some sort. Rather, you try to look a bit through the lens of that hearing officer and be somewhat deferential to them as the original hearing officer who's charged with the findings of fact, weighing credibility, and has the benefit of meeting with those individual students directly. And so there's a level of deference to the original hearing officer's decision that you need to keep in mind. And it's not just a brand new de novo review of the original case. You have to try and look at it through that hearing officer's eyes. All right. The other piece is whether the sanctions imposed were appropriate for the violation. So that is a place where you can be thinking about it through the hearing officer's lens, but you also get to, of course, bring some of your judgment into that and say, based on the nature of the violation and then the sanctions that were imposed, does this seem fair and reasonable? If the answer is yes, then great, you affirm. If the answer is no, and as a collective group you all tend to agree, or a majority of you agree, then you have that opportunity to recommend alternative sanctions and send the case back to the original hearing officer, who makes the ultimate final decision, but they take into account what you've suggested, what your rationale is, and then can determine whether to keep the original sanctions in place or whether they will modify the sanctions based on your recommendations. There's also a piece about whether there's new information that's not available at the time of the original hearing that may be relevant to the final decision. That doesn't come up very often. I mean, if we think about it, typically by the time a student has a hearing with the hearing officer, all sort of known information surrounding the incident should be generally available. So it's only if something brand new that really wasn't available at the time of the original hearing comes to light that at that point the appeal committee can consider whether it's appropriate to do a new review and consider that new information. But it's really critical to remember it's not about just a new argument or a new approach to the argument from the student who's involved in the case and who is appealing, but rather it's got to be new information that really was not available at the time the original hearing occurred. So the most important aspect of this when I'm thinking about your role on the appeal panel is understanding that there is some level of deference to the original hearing officer. And that's true in the criminal and civil court systems off campus as well, with the idea that the original trial judge or the hearing officer is the person who's in the best position to have that direct interaction with the parties involved in the case, is able to sift through the kind of facts and arguments that get presented, to weigh credibility of the people involved and the witnesses, and to make a determination about what did happen in this case. What are the findings of fact? And how do those match up with the conduct code and help establish whether or not a violation occurred? So it's very important to keep that hearing officer's lens as the original trier of fact, who gets to meet people, weigh credibility, all those things, to keep that in mind. And also understand that your review is limited to the case file, to the record of the original hearing. So whatever reports, witness statements, documents come into play for the original hearing, that stuff all gets put into a file, and then you've got the transcript or the recording of the hearing itself, and then any hearing officer's notes and such that helps highlight what jumped out for them in making their determination in the case. That's the record. It's the documents, it's the recording, it's the notes of the hearing officer and their final decision that they make. That's the record, and that's what you review to help look at and say, hey, was this hearing conducted fairly? Was process followed? What do we think about the sanctions and how appropriate are they? Your review is limited to that record. So you're not in a position where going out and trying to do your own investigation around the incident or the student, or to have side conversations with witnesses, or to call the police and try to get more information, or God forbid, call the DA's office. Don't do any of that stuff. It's not up to you to do the original or to do an investigation. Your review is of the record of the case. Whatever it is that is on file with the conduct office will be provided to you. You review that, and then you match that up with whatever the student's concerns are on appeal and how it matches up with the conduct code. So if I was there, I'd be available to answer any questions. If there are questions that flow out of this or any clarifications that I can be providing some more information on, do not hesitate to contact me, whether it's through Paul or if you want to contact me directly. I'm certainly happy to take a call and talk things through with you a bit more if you have any questions. So with that, I know you've got a great training today. There's a lot of really great people from a variety of offices that coordinate and work together with the conduct office very often, and so I know you'll get great material and information, and I appreciate again the service that you're providing to the institution and to the Student Resolution Center, and I hope it's a great year. Thanks.